In data protection law around the world, there are two competing principles that tug in opposite directions. And therefore, organizations trying to comply with data protection law have to struggle with these competing principles. On the one hand, data protection laws like the General Data Protection Regulation in Europe or the California Consumer Privacy Act may say something to the effect that the data subject has the right to cause something to happen with respect to their data, such as to have their data deleted or have their data corrected or to ensure that their data is not shared. Okay, those are important rights, important principles that organizations have to comply with. However, a competing principle is that the organization must secure the data. And a way in which security could come up as a question is someone comes to an organization and that someone says, "Hello, my name is Jane Doe, and I want you to do something about my data." The question is, how does the organization know that this is actually Jane Doe? Now, the organization might say, well, if you come to my physical office and you show a government-issued ID, then I'll know for sure that, in fact, you are, in fact, Jane Doe in my records, and you're asking me to delete the records or give you access to the records. Okay, then I will do that. But so often in our modern age, it's not convenient for this person claiming to be Jane Doe to physically show up in an office and show government-issued ID. So there is this struggle, this tension for data holders to figure out how far should I go to ensure that I'm dealing with the right person. To illustrate this problem, a researcher gave a presentation at a hacker conference called Black Hat in Las Vegas way back in the good old days of 2019, well before the pandemic had happened. And this researcher said, I'm looking at GDPR in Europe, and it says that the data subject has the right to access her data held by a data holder. So she should be able to go to a data holder and say, I want you to give me access to my data. I want you to tell me all the data that you have about me. So the researcher located in the UK explained that he has a fiancée. She is a female. She is an American. The researcher is a British male, and he says, we go around Europe and we go to hotels and we go use train services. Then he goes back to the UK. He creates a fake email address and he uses the name of his fiance, but he goofs up the name a little bit on the fake email address. And then he, not the fiance, he, the male researcher, sends emails to places where they have done business around Europe, like a hotel. And so they send an email to the hotel and they say, under GDPR, I am entitled to access to my data. So please give me all the data that you have about me. So he sends numerous emails like this, and he starts getting interesting emails back from hotels and railroads. And therefore, he's able to get the mother's maiden name of his fiance, social security number of his fiance, full a travel itinerary of his fiance. Then he goes to Las Vegas and he says, hey guys, do you think that a stalker or an identity thief might be able to take advantage of this data? Oh yeah. And so in effect, he pointed out that the politicians who have adopted and promoted GDPR in Europe have made a lot of emphasis on, data holder like a hotel, you must give access to the data. But the politicians have not made so much of a point about saying, but before you give access, you have to confirm the identity of the person who is asking for the information. And that can be really challenging. So to explain how an authority has wrestled with this, in California, the state of California legislature adopted the California Consumer Privacy Act, and it says, for example, that the data subject can go back to a data holder and say, I want you to give me access to my data so I can port it to some other service provider. And so the data holder has to turn over all of the data, like social security number, driver's license number, credit card number, and so on. But the big challenge in California is to determine how much must the data holder confirm the identity of the data subject. That's a difficult topic. So the Attorney General in California had the unenviable task of writing regulations to interpret this law written by the legislature. And the Attorney General acknowledged, this is a difficult problem, because it would be ideal for the data subject to physically show up and show her driver's license to be able to get access to the data, but that's not very practical for all kinds of reasons, like the pandemic, for example. And therefore, the Attorney General said that the data holder has to go through a complex risk assessment to evaluate the likelihood that the person asking for the data is not actually the true data subject. So what we see here is the Attorney General of California acknowledging the legislature can write a law and it has strong power saying that the data holder will turn over the data, but then a logical interpretation of the law recognizes we also have to secure the data. Therefore, we have to take a detailed risk assessment to identify or confirm the identity of the person who's actually asking for the information. I teach a 5-day course at the SANS Institute. The name of that course is Legal 523, The Law of Data Security and Investigations. You can learn more about that at sans.org. You can also learn more about me and my practice of law at benjaminwright.us. Here in this video, I've given some ideas that can help to address legal compliance or legal risk. Obviously, through this video, I'm not your lawyer, and if you need legal advice, you need to go hire a lawyer to give you specific legal advice. This video is only for public education.